In addition to the diversification of the notion and the expansion of the scope of the maritime security, it is now very important to take into account the uncertainties due to the recent rise of nationalism and authoritarian regime in some states.
Beyond military presence, France and Europe contribute to maritime security in the broad Indo-Pacific by building the capacities of their regional partners so that they can better monitor their.
I see FOIP as a very useful tool, not just for powers that may be great powers, but actually for middle powers and what I would frame as middle power agency. So the interesting thing about the flexibility of FOIP is that it provides a lot of different vehicles of engagement. So if you think, look at Japan's case, you have bilateral engagements, you have trilateral engagements, you have quadrilateral engagements, you have, of course, multilateral forums that you engage with. So I think FOIP provides a platform that doesn't just have a one-stop shop where the great powers can engage.
Good evening, good afternoon, or good morning, depending on where you are located. Welcome to RIPS webinar on East Asian maritime security and Japan's territorial integrity. Thank you very much for joining us today. My name is Hideshi Tokuchi. I'm the president of Research Institute for Peace and Security, or RIPS. On behalf of RIPS, I would like to say a few words at the outset. RIPS is a think tank in Tokyo, Japan, established in 1978. It is Japan's oldest independent think tank dedicated to security studies. This year also marks the 10th anniversary of the ruling of the Permanent Court of Arbitration in The Hague on the South China Sea dispute. The historic verdict should not be dismissed as part of the history of the early 21st century. The situation involving the South China Sea is worsening. It is often said that Ukraine today may be East Asia tomorrow. I would say the South China Sea today may be the East China Sea tomorrow. The South China Sea issue is not someone else's business. It is business for all of us. Likewise, the Ukraine issue is not someone else's business either. It is also a business for all. We have 3 leading speakers and 4 prominent experts today. First, I would like to invite all the 3 speakers to make their initial remarks. I will introduce today's speaker in the speaking order. First, Professor Mariko Kawano of Waseda University, Tokyo. And second, Dr. Céline Pajon, head of Japan Research, French Institute for International Relations, or IFRI. And third, Mr. Jonathan Berkshire Miller, Senior Fellow, MacDonald Laurier Institute of Canada.
I'd like to express my most sincere gratitude to Dr. Tokuchi and his colleagues for their excellent efforts to realize this opportunity. Thank you very much. It was pointed out in the United Nations Secretary General's report on the oceans and the law of the sea in 2008 that the legal regimes for maritime security and maritime safety, which largely developed independently one another, have common and mutually reinforcing objectives. It also took the view that as the new and evolving threat at sea recognized no national boundaries are connected and must be addressed at all levels as a matter of concern of the international community and collective security. This view signifies that maritime security today involves a variety of factors and that all members of the international community have the common interest in maintaining and enhancing the maritime security and incorporating for that purpose. In addition to the diversification of the notion and the expansion of the scope of the maritime security, it is now very important to take into account the uncertainties due to the recent rise of nationalism and authoritarian regime in some states. For example, Trump administration has utilized economic measures as coercive measures and has made the distinction blurred between military and law enforcement operations. It is true that the gray zone issues are one of the most highly debated issues of international law in the context of maintenance of the maritime security. However, the legal restriction of measures to be taken is still valid despite the alleged legitimacy of the purpose of the operation. I think that military operation is not appropriate to regulate crimes at sea. Another example of the problems of nationalism and authoritarian regime may be reflected in the assertive activities by those states. While coercive measures to enhance territorial claims or to change the status quo by forceful measures may be effective to appeal to the nationals in the domestic society, those measures cannot be justified by international law. When we consider how to maintain the maritime security by legitimate measures, the essential point to be noted is that despite such uncertain and unstable circumstances, the conduct and policy of respective states to maintain maritime security is required to be pursued in accordance with international legal rules. The United Nations Convention on the Law of the Sea, UNCLOS, which provides the principal framework for the international law of the sea, sets out the rules allowing the coastal state exercise sovereignty over the territorial sea and sovereign rights and exclusive jurisdiction in the exclusive economic zone and the continental shelf. States other than the coastal state are required to respect those rights of the coastal state.
And also, thank you very much for keeping the time. Thank you. Well, next speaker, Dr. Céline Pajon of France. You have another 12 minutes. Go ahead, please.
Thank you so much, Tokuchi-san. Thank you for having me for this important discussion. I would like to follow up on one dimension Kawano-san touched upon, that is the European perspective, a European contribution to the rules-based order in the Indo-Pacific. France is a resident nation of the Indo-Pacific, the territory in both Indian Ocean and Pacific Ocean, and a very, very, very big economic zone that represents actually the second largest EEZ in the world. So that's a very big maritime territory, and protecting these areas against predatory moves is France's top priority for the Indo-Pacific. So as you may understand, the cornerstone of France's approach is thus the promotion of the rule of law, particularly at sea, and with the respect of UNCLOS to ensure stability and protect its territory as well. Defense Minister of France, Jean-Yves Le Drian, made some remarks at the Shangri-La Dialogue, saying that what's happening in the South China Sea could happen also in the Atlantic or Mediterranean seas, I mean, closer to Europe. So we need to push back again this kind of violation of the rule of law, even in the South China Sea. I think that it's signaling a very strong political commitment and demonstrating solidarity with partners in the region vis-à-vis a revisionist state, which is quite important. Beyond military presence, France and Europe contribute to maritime security in the broad Indo-Pacific by building the capacities of their regional partners so that they can better monitor their sea territory. In addition, I would like to add that France is a P5 country and a key partner also to uphold some international regimes like non-proliferation, And France and other European countries have also been involved in the enforcement of the UN sanction on North Korea for several years as well. So in the age of great power competition, what roles for European or the French in the region? Right now, it has been recalled also by Kawan-san, the international security framework in Asia remains fragmented. ASEAN Code of Conduct negotiations face difficulties and limitations, and we've seen a flurry of unilateral initiatives to try to facilitate the coordination among like-minded countries. But the overall geopolitical competition, especially between the US and China, often leads to suboptimal coordination in tackling these maritime security challenges. So I think in this context, France and Europe has potentially an important role to play as normative power. Again, they can help.
The third speaker, Mr. Jonathan Bakshamila. Jonathan, your turn.
I think it's important when we're talking about FOIP and the free and open Indo-Pacific that we go back to first principles, because I think often when this discussion comes up about Indo-Pacific strategy and even about FOIP itself, some people have an amnesia and forget that the intellectual origins of FOIP, I know the Japanese don't forget, but I think that many capitals outside of Japan forget that the intellectual origins of this strategy really come from Japan and from the region. So I think it's important right now to reiterate that and to reiterate the buy-in and the equity for the FOIP idea, of course, in Japan, but more broadly in the region. Some of the thinkers, for example, in Australia, in India, and elsewhere. And one of the things that worries me about this, and you can see this in the G7 context, and you can see this in the scope of many of the mini-laterals, is you have your maritime security element, but you also have the utilization of economic tools for coercion against other states. The third point that I'd mention is, and this sort of links into eventually talking about Canada and other middle powers, is that I see FOIP as a very useful tool, not just for powers that may be great powers, but actually for middle powers and what I would frame as middle power agency. So the interesting thing about the flexibility of FOIP is that it provides a lot of different vehicles of engagement. So if you think, look at Japan's case, you have bilateral engagements, you have trilateral engagements, you have quadrilateral engagements, you have, of course, multilateral forums that you engage with. So I think FOIP provides a platform that doesn't just have a one-stop shop where the great powers can engage and middle powers feel isolated. I actually think it provides a very important opportunity for middle powers to find a space to engage. And what I would say for a country like Canada, and we're a little bit new to this way of engaging, because we're a type of country that loves multilateral engagement as a primary vector of our international engagement. And so my final point before turning it over to discussion is just going back to this idea of FOIP being operationalized. So I think we want to get beyond the abstract, beyond the theorizing. We all know the rule of law is important. We all know the threats that we face, whether they're in the South China Sea, whether it's DPRK, Senkaku, etc., Taiwan Straits. I think we really need to focus on FOIP being more operationalized. And that looks at those very specific areas that I mentioned in the onset of how can mini-laterals be effective at actually providing those goods. I think we're starting to see now with the Quad, hopefully we're going to see this more with AUKUS, Pillar 2 and other areas, where we see very precise things where Indo-Pacific powers are actually providing goods to the region and contributing to peace and stability. But I think in the coming years, and I'm really hoping Takaichi's sort of evolution of FOIP from a Japanese perspective focuses less on the theoretical of why we need FOIP, but actually on this operationalizing FOIP in a meaningful manner. And I hope countries like Canada, France, and others that are represented here continue to play a big role.
I wonder, if Jonathan, Mr. Mbira, can you answer the questions from question from Professor Satake about defense posture of Canada? We have to secure enough time for Q&A with the audience. So 1 minute, please. Japan. I don't know, but anyway, Professor Kawano, 2 questions about. One is about multilateral frameworks contribution to law enforcement, maritime law enforcement, and also what's your recommendation in the case of absence of respect of diplomacy and law? Just briefly, please.
Yeah, thank you for your questions. With regard to the examples or effectiveness of unilateral or regional cooperations, for example, in the Secretary General, since 2008, the Security Council have dealt with the issues with regard to the maritime security, and their argument covers not only the military security, but also the crimes at sea or something like that. And then at least I can take up some example of the regulation of the IUU fishing. That means illegal, unreported, and unregulated fishing. I mean, the small countries, small island countries in the South Pacific have formulated some sort of mechanism for cooperation to regulate that sort of IUU fishing activities. And they also contributed to the request for the advisory opinion of the International Court of Justice in the case of the climate change. So those activities are definitely have contributed to the formulation or new trends of international legal rules. And with regard to the absence of the respect of international legal rules. For example, in the case of Japan, at least Japanese government has tried to formulate their diplomacy or diplomatic policy all the time on the basis of the respect for international legal rules. And this has been some sort of Japanese government's basic policy since the end of the Second World War. And we have to emphasize the importance of the diplomacy on the basis of international legal rules. So this is my recommendation to other countries which neglect the importance of international legal rules. Thank you for your time.